Professor Bordone, thank you very much for joining us today within 16 minutes of ADR. So today we're going to talk about the ADR education and clinical programs. So first let's talk about the Harvard mediation and negotiation programs. There are many of them actually at Harvard. And if you can describe the history of those programs and how you could develop them.
So the negotiation and mediation program generally at Harvard Law School began about 35 years ago. And really a number of forces, I think, were influencing this, but two people in particular are on the law school faculty. So one was Roger Fisher, who was an international law professor, and the other was Frank Sander, who actually was a family law professor and actually a tax law professor. Roger, I think, had always had an interest in negotiation, and in the mid to late 80s started to offer a negotiation seminar. And Frank's work really was really coming out of an observation of the way courts, family courts, treated families, and thinking there had to be a better way to handle this. And so he became interested in mediation and started to teach a mediation course. And his work around ADR even started earlier in the 70s. And so pretty soon Roger and Frank started offering negotiation and mediation, and then started to see others in the university, people like Larry Susskind at MIT, people like Howard Rafa at Harvard Business School, also having an interest coming from different disciplines around negotiation work. And so in 1983 is when the program on negotiation at Harvard Law School started. And when I was a student here at the law school in the late 1990s, the negotiation workshop had grown a fair bit. And the law school then had a mediation program, and that mediation program was what we call a student practice organization. So entirely student run. And really people mediating in one of 13 community courts. And that program, the Harvard Mediation Program, still exists today. During my time, though, besides the mediation program and maybe being a teaching assistant in a negotiation workshop, there weren't a lot of active things you could do in negotiation or ADR once you've taken the mediation, the ADR, or the arbitration class. However, in the late 1990s, Professor Manukyan had gotten funding from the William and Flora Hewlett Foundation to fund research fellows, who are people who are interested in careers in negotiation and dispute resolution. And so during my time here at the law school, I was one of those research fellows. Interestingly, at the same exact time, now Professor Guhan Subramanian was one of those research fellows, and the current United States Ambassador to the UN, Samantha Power, was one of those research fellows. So this was a very, I think, arguably worthwhile investment of the Hewlett Foundation. And it was really in the mid-2000s, at a time when clinical legal education was really booming across the nation, and my own interests were really moving into dispute systems design, that I proposed to then Dean Elena Kagan that we actually start a clinic in dispute systems design here at the law school. And so that clinic started, it was really just me and a few students in 2006, 2007, and has grown a fair bit since then. We now have a seminar on dispute systems design, we have a multi-party negotiation class, we have a class on the lawyer's facilitator, we work with a whole range of clients, both within the United States and internationally, in the private sector and in the public sector. So in addition to running the clinic, I also am the faculty supervisor for 3 different student orgs related to negotiation and dispute resolution. So one is the Harvard Mediation Program, which I mentioned earlier. That was actually started, I think this will actually mark its 35th anniversary. The other is Harvard Negotiators, which actually started around 2005 or so. And the third is the Harvard Negotiation Law Review.
You currently supervise student-run ADR-related organizations at Harvard. One of them is Mediation Program, Negotiators, and Harvard Negotiation Law Review. So if someone would like to start something like this at their university, how would you recommend what they need to do, what are the steps, and what are the key factors that influence on building a successful program?
I think my advice to a school or somebody who wanted to start this is is to start off in a focused way. So if it's faculty who are starting it, a lot of the work just really should focus on the domain that is interesting to the faculty member, and I think that students will see enthusiasm and excitement, and they will kind of join the endeavor. I think if students are getting started, I think similarly, right, they should have some kind of very specific goals about where they want to be in year one, where they want to be in year five, and try to identify faculty whose research areas or work might actually support what they want to do. The challenge with setting up a mediation program is it takes a fair amount of time, energy, and work to build relationships with local courts. And so you need people who can do that, who have the connections, and can build the trust. So that could be harder for students to do who are only around for a year or two. It often requires some staff. So I think that what you really want to do is get a set of students and faculty who are excited about making something happen, and develop a negotiation strategy to get the support of a dean, get the support of a foundation, get the support of a local court.
Most ADR programs, whether it's an institution, an educational program, a clinical program, they always have a problem of sustainability. So can you talk about how to make the program sustainable?
I think some of the real challenges are assuming that you want to do this within the contours of a university. So one is the basic challenge of funding. I think a real unique challenge that ADR faces is that it's decidedly interdisciplinary. And because of that, it sometimes can get lost in a university where often promotions and hires are around disciplinary writing and thinking. In order to keep things kind of going, right, it is helpful to the degree you can get support of prominent people within a university or prominent leaders who say these are, things worth doing. And I think, part of it is doing really high quality work, right? I think two things you want to do. You want to do really good work, and you want to make sure people know about it. If you're doing crummy work, if you're careless, that's going to hurt the field, that's going to hurt your program. If you're doing really good work and never tell anybody, that's hard to get, it's hard for people to know.
Yeah. So Harvard Mediation Program is a unique one. It provides an opportunity for the students to go to the local courts and mediate real cases. Can you talk more about the importance of linking the educational programs with the judiciary and how you could do that at Harvard?
So I think one of the great advantages that a program like the Harvard Mediation Program has is we are working in 13 different courts. So students are getting to see the way the legal process actually happens. And they're getting to actually work with the people who come in that day. They think the judge is going to hear the case, right? And instead they're mediating the case. So I think that's an invaluable educational experience for students. I think also, depending on if I think about our clinic more broadly, so we did a project this past semester with the New Hampshire court system and we actually did this also in the last fall and this fall, on the criminal justice system, where we get to see what do settlement conferences look like. And so students are really learning a discrete set of skills, but they're also learning where negotiation and mediation can play a role. Areas where maybe what we have to offer can actually be enhanced. And also, they get a sense of just how different judicial processes work, right? The pros and cons of, if, for example, in a mediation, it doesn't work, those litigants go back to court and the judge hears them that day, right? So they get to see that result as well. So I think it's pretty rich. And students who are around kind of all 3 years here will often mediate in different courts. And so even in this local region, you get to see pretty big variation in the way courts and judges operate.
Right. You have published an article about teaching law students design dispute resolution systems. I know it will be impossible to talk about this within a minute or two, but can you talk just about the principles of teaching dispute system designs?
I think the main things I would say, right, is one, identifying a broad set of stakeholders is the most important thing in a system. Secondly, learning to ask really good questions about a few things. One, how do conflicts currently come up in the organization, what kind, etc. Two, what processes are currently in place to manage or resolve them. Three, how are people actually managing or resolving them? Because there may be, and typically is, a big difference between the two. And then four, what might be some better ways and by better ways, that people would be more likely to access because they trusted in it, because they thought it was easily accessible, and then what might be the barriers to actually implementing that. And so on those last two questions, the design process is usually a consensus building process, bringing the stakeholders together to kind of co-construct it with the help of hopefully someone who knows something about the field.
In ADR emerging economies, such like Armenia, the scholarship and legal writing about ADR is key. Can you talk more about the principles of the scholarships and foundations, how to build those, and what is the importance of the scholarship?
So I think from my perspective, starting actually with systems design before mediation and negotiation, actually. So I think the notion that ADR needs to be ADR is not something that I buy. I think if you can get in on the ground floor and have some of the design principles embedded, kind of hardwired in the legal system, then you don't need something called ADR because it's already included in the system. So I think teaching law students early on diagnostic skills so that they can really understand what is the nature of this conflict, and then what an appropriate prescription might be, is critical. And that is something that we don't do in U.S. law schools, right? In U.S. law schools, we essentially mostly teach one prescription, which is litigation.
You have received many awards and prizes in relation to your teaching and academic activities, and many of them actually relate to teaching excellence. And can you describe what makes a good ADR teacher?
I think this is not just for ADR. This is generally, right? Being interested in students and being interested in more than just like their kind of analytical thinking, but being interested in them as a person, right, actually makes you a better teacher. Because if you're interested in them as a person, you can be responsive to them and engage with them. I think with respect to ADR, creative pedagogy, so Frank Sander and Stephen Goldberg wrote a famous article called Fitting the Form to the Fuss. I think there's something to say about fitting the teaching pedagogy to the purpose. I mean, that's not something that teachers do very well. But thinking about what is my purpose today, what is my big message unit, my BMU, right? And then how is what I'm doing today in the classroom kind of tailored to achieve that? And so using a combination of lecture, discussion, simulation, video, even getting people to move around the room kinetically, physically, using stories, using social science research. So bring it all together, not just having kind of a mode of teaching. but having many modes of teaching, I think, are really important qualities. And I think there's a real openness in ADR to do that more than in some of the more traditional topics.
Thank you very much, Professor Bordone, for this interview.
Yeah, thanks for interviewing me. It was fun.